This is Judge Herb Dodell, and the show is called For the People. It's called For the People because it's for you, the people, so that you can anticipate what you might find if you get involved in the judicial system, both civilly and criminally. Now, I was a trial lawyer for 50 plus years and had 99 jury trials, excluding those that I did as a deputy district attorney for the county of Los Angeles. There's a big difference between civil and criminal, and most people have heard terms here and there but don't know what they really mean. Criminal proceedings are generally begun by one of two methods. The first is called grand jury indictment. People have heard that term many times but don't know what it is. Well, the grand jury is a group of citizens that are brought in and they hear evidence that's offered by the prosecution only. There's no defense being offered. And people are subpoenaed to testify before the grand jury, and the prosecutor makes their case. Having been a deputy district attorney myself, I participated in grand jury proceedings, and it's a general one-sided presentation. And if the grand jury decides that a crime has probably been committed and you, the defendant, is probably the person who committed it, they issue what's called a true bill, and you get arrested. And the next step on this process, which is a little different than the second one, which we're going to talk about, is you go to trial. The second one, which is more prevalent, is called a complaint, criminal complaint. And what happens is law enforcement comes to see you, gives you all the information that they have, why they believe that a person should be arrested. And I was a filing deputy for the district attorney's office, which meant I interviewed police officers and made a decision whether to file a charge or charges, and sometimes we even overcharged, which we talked about in another session. And a criminal complaint is issued, and perhaps an arrest warrant, and they come and get you. That case is a little bit different because you are entitled to something called a preliminary hearing in California. A preliminary hearing is like a mini trial. The prosecution puts on a bare bones case. In fact, it's been somewhat limited now in California of what you could get in. Hearsay, everything applies. And a judge decides whether there is a reasonable basis, probable cause, to believe that a crime has been committed and you, the defendant, have committed the crime. You have the right to cross-examine all witnesses that have been offered by the prosecution. I used to use it as a discovery device. I would subpoena witnesses and put them on, even though, generally speaking, defendants do not put on a defense at a preliminary hearing. The end result, usually, I'd say probably 95% or more, is that the defendant is called held to answer, meaning they are arraigned thereafter. An arraignment is a proceeding where you say guilty or not guilty. 99.9% of people say not guilty no matter what. That's an arraignment. And after an arraignment, after being found held to answer, you set for trial. There are intermediary proceedings, generally dealing with mechanical matters, witnesses, documents, exhibits. There's no real discovery in a criminal case, while there's lots of discovery in a civil case. If you want to know more about the subject, and it's really very broad, we certainly can't deal with it in a couple of minutes, contact me at askjudgeherb@gmail.com, or read the section on criminal law if we're talking about criminal law in my book, From the Trench to the Bench, available on Amazon.